Hi, welcome to Business Organizations. This is Lecture 12. Tonight we will cover the qualifications of a foreign corporation as well as changes in corporate structure. So, what if a corporation wants to cross state lines and they want to do business in another state when they are incorporated here in the state of Florida? Say they want to go do business in Georgia. They've saturated the market here. They're making lots of money, but they just feel like they can do more and they want to do more. Well, we have statutes on that. Each state has statutes on qualification of foreign corporations. A foreign corporation isn't an internationally foreign corporation, although it can be. But if another corporation from another state wanted to come in, they would have to qualify as a foreign corporation to come in and do business in the state of Florida. So basically, that's getting permission to cross state lines and come in and make money by doing business in your state that we're not incorporated in. A foreign corporation, let me just give you a couple of definitions that I want you to know. A foreign corporation is a corporation which is transacting business in a state other than its state of incorporation. A corporation does not legally exist beyond the boundaries of its own state, where it incorporated. And it must therefore be granted permission to do business in other states. This permission is called qualifying to do business. So you have to get a hold of that state and find out what they require, and then you have to make sure that your corporation jumps through all those hoops. And a lot of them are very similar. So determining when a foreign corporate qualification is necessary. You don't automatically, let's say your business, you just wanted to buy a piece of property in another state. Chances are that one transaction is not going to mean that you're doing business. If you do one simple transaction in another state, then you're not really doing business there, so you wouldn't have to qualify as a foreign corporation there. However, some states may have requirements that, well, if you own real property in our state, then you have to qualify. I feel a cough. Excuse me. Okay, glad we're not face to face. You have to research the other state. And always, don't just assume you know what it's going to take to qualify in that other state. You have to figure out whether their corporate qualifications for foreign corporations are necessary for you or not. So examine how the statutes construe the words transacting business. They'll have a definition that may be one business transaction is transacting business. Probably not, but they may have something that says if you do 5 to 7 transactions in our state a year, then you are transacting business in our state, and you do need to qualify to be a foreign corporation here. Some might say that if you have a pattern of transactions where every month you have one transaction in our state, that might be transacting business. So you have to look that up. You have to do a little research, and thank goodness you guys are paralegals and you know how to do this kind of stuff. Then you have to take a look at, examine, and research the procedure for qualifying. Okay, you find out whether you're transacting business. You determine, yes, in fact, we do want to transact business there. And so what do we have to do to qualify as a foreign corporation to be able to do that? And then you want to examine the penalties. Because clients are always going to say, this is very expensive to transact business as a foreign corporation. Why can't we just go do business there? As long as we don't break any laws, we'll be fine. Well, you want to be able to tell them that if they do get caught, these are going to be the penalties, and this is how much it's going to cost you. And so usually it makes a lot more sense just to pay the costs that are incurred qualifying to be a foreign corporation than to risk what the penalties might be. When corporations transact business in other states, they are subjecting themselves to that other state's courts and laws, and that other state's protections. So they do need to qualify. If it's required, they do need to qualify as a foreign corporation. All right. Typically, the statutory requirements for qualifying to do business, and I'm going to tell you what usually other states require. If you have a Florida corporation, your client was incorporated in Florida, and they've come to you and they say, hey, we want to go do business in North Carolina, then you will have to do the following generally. You're going to look up the procedure, and in order to find out what the procedure is, you're going to have to go to the corporate code. They're going to have a statute, like we have our statute 607, our whole chapter 607 on corporate behavior and corporate law, kind of. You're going to have to go find out what that is for the other state. And then you're going to have to look up qualification of foreign corporations. You look to see how that state statute defines transacting business. You make sure that's what your client wants to do there. And then you determine whether your corporation will be transacting business based on their statute and case law, which interprets that statute, or if they will not be transacting business. If they are, then you want to figure out, okay, how do we qualify? We know what we want to do requires that we qualify as a foreign corporation. So what do we have to do now? You're going to read the statute, and you can call the Secretary of State. They are surprisingly helpful when you're a corporation and you're calling in and saying, hey, I'm incorporated in Florida, but I'd really like to do business in your state, and I want to qualify. That means I'm not trying to sneak around and make money off of your citizens. I want to do what I have to do, what you require of your foreign corporations to do. They like that, and they want to be helpful, and they'll let you know. They probably can just shoot you or send you an email and say, yep, here's what you got to do. So typically, I'm going to let you know what it's going to be. Usually it's at least these things, and then they may have some more little quirky ones depending on what state you are in. In general, you have to file something called a certificate of authority. And in order to file a certificate of authority, that means I have the authority from the great state of North Carolina or whatever state you're wanting to practice in or do your business in. I've got the authority to do my business here in this state, North Carolina. Then you're going to have to, before you can get that, you're going to have to obtain something from your own Secretary of State. Back here in Florida, you're going to have to come and ask for a certificate of good standing. It's also called a certificate of existence. It means, yep, I'm in existence. I am a corporation in Florida. And it will tell North Carolina's Secretary of State whether you're in good standing or not, whether you've been following the rules here, whether you're behaving yourself or not. So once you have the certificate of good standing, you file that with the certificate of authority with the state that you're trying to go to, let's say North Carolina in this. You figure out if there's any name requirements. Sometimes they do, sometimes they don't have name requirements. Then you appoint and maintain a registered agent. So you're going to have to figure out, do we know anybody in North Carolina who would be willing to do this? Are there companies that do this for foreign corporations where they'll accept service? And if we get sued, then our agent will let us know. And then, of course, you will have to pay the appropriate fee there in North Carolina so that you can go do business there. That's pretty much it in general. That's about what most states require. And like I said, unless there's something extra, then you're good to go once you get all of that stuff in line. But make sure that you go and research their corporate statutes and specifically qualification for foreign corporations. All right, let's say you have a friend who's representing somebody from here in Valencia. They moved to Arizona, and now they're working for a law firm in Arizona that represents a corporation that wants to come make money and do business in the state of Florida. And so they're like, I know Professor Higgins said something about that. I can't remember what it was, but I remember so-and-so, Susie Jane, was in my class, and so I'm going to give her a call. So you might have somebody that calls you and says, hey, we want to do business in Florida. What do we do? And, I've found it's always good to be nice to people. It's always good to leave people feeling like you give them good information, you take care of them, you're happy to help, you go the extra mile, because you never know when people are going to need you. So what you tell them is, well, very simply, Florida statute, I'm sure you remember chapter 607, look in section 1501 in the Florida statutes. It states that a foreign corporation may not transact business in this state until it follows the procedures set forth in 607 1503 of Florida statutes. The statute then attempts to give you an incomplete list of activities that do not constitute transacting business. That means it gives you a whole list of things that says, if you're doing this, you don't need to qualify as a foreign corporation. So all of these corporations outside of the state of Florida that want to come in and do business, they want to be on this list. So they look, all right, maintaining, defending, or settling a proceeding. No, if somebody gets sued and they're coming here to settle it, or they're coming here to file a lawsuit against someone in Florida, or, it's just that's their only business in Florida. No, that's not transacting business. They can come in and do that without having to qualify. Holding meetings, regrading internal corporate affairs. No, we want people to come here and have their corporate meetings and stay in our hotels and spend money and go to our restaurants. So no, that's not transacting business. You don't have to qualify to be a foreign corporation. Come on down and do that. We're happy to have you. Number 3, maintaining bank accounts. Maintaining bank accounts? Are you kidding? Please come put your money in our Florida banks. Number 4, selling through an independent contractor. We encourage independent contractors. So no, if they're selling through an independent contractor, that's great, because that independent contractor is here working in the state of Florida, and he's going to have income tax. So that's good for Florida. We want that corporation to be selling through him. Soliciting or acquiring indebtedness, mortgages, or security interest in real estate or personal property. That you don't have to qualify to do that. Securing or collecting debts. No, we want to encourage that. Transacting business in interstate commerce. No, that's fine. Transacting business in or conducting an isolated transaction that is completed within 30 days. No. So basically, if you have one transaction that you're going to transact in Florida and you can get it all wrapped up in 30 days, you don't have to qualify to be a foreign corporation doing business in the state of Florida. Owning or controlling a subsidiary corporation or limited partnership transacting business in Florida. Don't have to qualify. Owning real or personal property that exists here in the state of Florida. No. So all of these are what corporations try to fall under one of these exceptions, where you're not transacting Florida if you're just doing that. Otherwise, you are transacting business in the state of Florida. If you're coming here and you're trying to set up shop and make money here in the state of Florida, then yeah, you're going to have to qualify. So what are the procedures? Again, looking under 607.1503, if you have good standing, then you can get the certificate, which is the certificate of authority to transact business in Florida. You have to call the Department of State and you ask them to mail you a form called the Certificate of Authority to Transact Business in Florida. And the form, you'll fill it out. It's a simple, just fill in the blanks. What is the name of the corporation? Now remember, the name must be available in Florida. If not, the corporation can use an alternate name and then let the state know that you are doing what you are doing. Also, the name has to comply with the name requirements. Remember, if you're a corporation here in the state of Florida, you have to have Inc., I-N-C, period, or incorporated, or corporation or company in your name. Which state where were you incorporated? So you've got to tell them where you were incorporated, the date of your incorporation, and the period or duration if you have a duration set for your corporation. The address of your principal office in the state that you're in, the name and registered agent that you have here in Florida, because you have to have an RA here in Florida. Names and addresses of all your current officers and directors. And then you send, after you fill out that, you send it all back to the state with a completed certificate of authority and your certificate of existence, which is the certificate of, I like to call it the certificate of good standing, from the state of incorporation. You show us that you have an appointment and acceptance of a registered agent, and you pay $70. So there's a lot of fees in the world of corporations, but they're very cheap. They're very cheap to be a corporation because states like them, and they like people coming and doing business in our state. And then I have added this. If the corporation is transacting business in a foreign state, anything significant, if there's a change, then the corporation must file an amended certificate of authority. So that just kind of makes sense, but it's important not to forget. All right. Rights and privileges. Let's talk about rights and privileges of the foreign corporations. In other states, you, the Florida corporation, you have to meet the statutory requirements. You have to file corporate reports, annual reports if they require them, and you have to pay the other states any fees and taxes that they require. This is if you are here in Florida and you are going to the state. Not only do you have to pay Florida and meet all the Florida requirements, but you also have to do the requirements and satisfy the requirements for the other state that you are qualifying to do, that you are qualified to be a foreign corporation in. It's not that big a deal. It's a pain in the neck, but it's not that big a deal because once you have your annual report, you can file that in Florida. Okay, you have to file it in North Carolina too, if that's the other state that you're doing business in. All right. If you are another corporation that's incorporated in Delaware, let's say, and you're trying to come into Florida and you want to do business here in the state of Florida, you have to go check out Statute 607.1505. Authorized foreign corporation has the same rights, the same duties, the same restrictions, penalties, and liabilities that are imposed upon domestic corporations. You're responsible for timely filing annual reports, like all of our Florida corporations have to do. You have to maintain a registered agent, just like we do. If you go without for one longer than 30 days, guess what's going to happen? That's right. You're going to be dissolved. Incorporators, directors, and officers must make truthful statements to the Department of State, maintain good standing in the state of incorporation. So if you don't maintain good standing in, let's say you're coming from Arizona, and Arizona dissolves your corporation, then you're going to be dissolved here. So that's one of the things that we require, is not only that you show us you have proof of good standing, but that you maintain it. And the last one is answer interrogatories propounded by the state. If the state of Florida gives you interrogatories, wherever you may be, if you want to be qualified to be a foreign corporation here, then you have to answer our interrogatories whenever we send them to you. Okay. And then I have some notes here for you to see on how to seek reinstatement if for some reason, as a foreign corporation, you lose your privileges. Okay, the consequences for not filing. So again, you might have some clients that are like, that seems like a lot of work, and I don't know. I just think, gosh, how would they ever know? I'm just gonna take my chances and see what happens if I don't qualify. All right, you want to make sure that your client understands. Other states, if you're going to go out to other states, generally you're prohibited from suing on a contract to enforce a contract or fines or anything like that. If someone's not paying you, then you're barred from suing them if you haven't qualified as a foreign corporation. You can't sue them until you register and pay all of the back fees that you owe that state. Okay. If that is a foreign corporation that comes to Florida and they don't qualify, they should have qualified, but they didn't qualify as a foreign corporation. Number one, they cannot sue until they file their certificate of authority, or they can't defend either. If somebody sues them, they can't defend. So imagine if somebody's suing you in the state of Florida and you're trying to cut corners, you didn't qualify to transact business in the state of Florida as a foreign corporation, and the plaintiff wins and they've sued you for $250,000, you feel pretty silly that you didn't pay whatever it is to $35 or $70 to qualify as a foreign corporation in Florida. Okay, number two, they will owe the state all back taxes from the time they began transacting business in Florida without qualifying until to bring them up to date until they're due. And there is a civil penalty of between $500 and $1,000 for each year that they did not pay to be qualified in the state of Florida. So if you're transacting business in the state of Florida and you don't have a certificate of authority, then if you get caught, they're going to go back to the very beginning and they're going to charge you between $5,000 and $1,000 per year. Okay, withdrawing from doing business as a foreign corporation. Other states, it's really set out by statute, but generally you just obtain and file an application for withdrawal of doing business as a foreign corporation in that state, and you get that from the Secretary of State. In Florida, if a foreign corporation decides they don't want to do business in Florida anymore, they also apply for a certificate of withdrawal for $35. Everything is $35, I think. Name of the corporation, name of the domicile state, state that it is not transacting business in Florida and it surrenders the authority to do so. They have to revoke the authority officially of the registered agent. They have to give their mailing address and commitment to notify the Secretary of State or the Department of State if there are future changes in the mailing address, and file the $35. So that is how you qualify as a foreign corporation in Florida if you are from another state, and also if you are incorporated in Florida and you want to go to another state. So generally the rules are very similar, but you always have to check that statute because there's always going to be something crazy and wonky. Either in your case, you're going to find something with the state statute. There's always something, so never think, I've got this. I've done this 1,000 times. If it's your first time that you're trying to do business in Idaho, pull the statute and look at it, read it. All right. The next part of this lecture is going to be on changes of structure. And when I talk about changes of structure, I'm mostly talking about mergers. When the structure of I've got a little thing here. The structure of the corporation is going to change. All right, now I don't know if I can get this up really where you can see it, but I have this form, and I want you to pull it out as I'm talking because this is the form that, it's not a form, it's a chart. This is the chart that I love. Okay, let me give you a few definitions before we jump into this. When a corporation reorganizes, whenever a corporation is doing a corporate buyout or whatever, a merger, it is called by the IRS a, quote, reorganization. So you've got a company and you've got another company, and they may reorganize into another company and become a brand new company, or they may reorganize and this company kind of just eats up this company, and it kind of, just becomes a different company. It stays what am I trying to say? It stays the original company, but it's got parts of this company in it now. So, looking at figure 14-3. A parent corporation is the corporation that creates another corporation. Like when my husband years ago was working for the Golf Channel, and then they realized, oh, you know what, we love, showing golf events, and but we really want to grow the game of golf, and so let's have little classes, let's do golf lessons online, and so then they started doing that. And then they were like, let's create something that help, teenagers and young people get tee times better. So then they created something called Golf Now or Golf Pass, I'm not sure. So there were all these other little subsidiaries that started splitting off from the Golf Channel. So the Golf Channel was the parent, and then you had these little subsidiaries. The subsidiary corporation is a corporation owned and formed by a parent. So you have the parent corporation that forms a subsidiary, the little kid corporation. Now, a merger is the combination of two or more corporations, whereby one of the corporations survives and completely absorbs the other corporation. Sometimes it absorbs more than one. The original, the other corporation that got absorbed ceases to exist, and so it just exists only as part of the new corporation. So when you're looking at the merger, you've got A, B, and C. It joins with X, Y, and Z, and it becomes A, B, and C. So X, Y, and Z no longer exists. There's just A, B, and C, which is part of X, Y, and Z. This is what happened with the Golf Channel. I know I'm very familiar with these companies, so that's why I like to go back and use them. The Golf Channel was up and running really strong. NBC and Golf Channel was part of Comcast. Comcast ate it up, but then said, oh, we don't really know anything about running a golf channel, so you guys keep doing what you're going to do. And so Comcast is up there. Then they decide to join up with NBC. NBC Sports said, well, we do all the sports. All of the Comcast and NBC sports stuff is done by a corporation, a subsidiary called NBC Sports. But wait a minute, we don't really like that. They've got that crazy little golf channel down in Orlando. So what they did was they kind of absorbed it. They sucked it up to Sandwich up in Connecticut. Sandwich, Connecticut, I think. And so basically there's no more Golf Channel. What happened was they just, it was sad. There was like 366 employees here, and it happened over COVID. And they just said, you know what you're doing down there, we can do up here because we've got a studio and we don't really need you. And so NBC Sports basically just, I think 12 people went up there, and 366 were laid off. And it was very sad. But that's what happens when a larger corporation kind of eats up another one. So you can still see where they'll talk about the Golf Channel occasionally on NBC Sports, but it's not really in existence. There's no more studios here in Orlando. The buildings are empty. They've been gutted. They're trying to rent them out. It's kind of sad from my husband's perspective. So let's get back to our class. It's where a merger is a combination of two or more corporations whereby one of the corporations survives and absorbs one or more corporations, which then cease to exist. So you've got NBC Sports, Golf Channel. Golf Channel ceases to exist. They start doing what the Golf Channel does. All assets, liabilities, and obligations are transferred to the surviving corporation. So NBC Sports had to continue to pay rent on the building here that the Golf Channel rented. There are three main types of mergers. There's also triangular mergers. We're not going to talk about those, so if you see them in the book, ignore them. And there are reverse triangular mergers. Ignore those also. We're only going to examine the classic merger, the upstream merger, and the downstream merger. Okay. The procedure for merging two corporations is as follows. For the classic merger, the board of directors for each corporation adopts a plan of merger. This plan of merger has to be approved by the majority of the shareholders of each corporation, unless the articles or bylaws says differently. The plan of merger must contain the following information: the name of the surviving corporation, the terms and conditions of the proposed merger, the manner and basis of converting shares into cash, property, and other shares. The surviving corporation needs to deliver to the Department of State the articles of merger, and the articles have to include the plan of merger, the statement as to whether shareholder approval was required or not, and the statement about when the plan of merger was adopted by each corporation's board of directors. And then once they have all that, they go to Sunbiz, they file it for $35. Okay, that's the procedure for merging. Now we have upstream mergers and downstream mergers. So let's just take a quick look. I want you to look at the Figure 14-3, merger and consolidation. You see the merger there at the top. Then there's an upstream merger where you have the parent corporation and you have the subsidiary corporation, which is like the child of the parent corporation. So you have, here's the child, or here's the subsidiary, here's the parent. The subsidiary corporation in an upstream merger goes upstream and gets sucked in by the parent merger, okay, by the parent corporation. That's an upstream merger. Let's say now you have over here, you have a parent corporation, and it creates and has this little subsidiary corporation, and they're going along, and then the child, sort of like my children, start getting bigger than the parent company, and maybe it's more modern and it's doing different things, and this is the old-fashioned way of doing it, and it's not as creative or whatever, and all of a sudden the next thing you know, the parent gets sucked down into the subsidiary corporation, and it's gone. That is because you have the parent going downstream into the subsidiary corporation. That's a downstream merger. So when the child gets sucked back up into the parent, that's the upstream merger. And when the parent gets sucked down into this giant child, the subsidiary corporation, that's the downstream merger. And as long as you keep the parents higher than the subsidiaries in your mind, then upstream and downstream is very easy. Okay, then down here we have a triangular merger and the reverse triangular merger. Not even worried about that, but we are going to talk about consolidation. So let me find my notes. First, the effect of the merger. The merging corporation ceased to exist. So in the upstream merger, where you have the subsidiary getting sucked into the parent continues to exist, the subsidiary is gone. When you have the downstream merger, where the parent is getting sucked down into the subsidiary, the parent no longer exists, but the subsidiary exists. So the merging corporation ceased to exist. And the original, or the bigger corporation, the sucking corporation, is the one that gets to remain. Okay, but when the one that gets sucked up into the other one, the big one that remains, they are also sucking up all the debts, liabilities, any litigation that's going on, that stuff stays alive, and the corporation that is doing the sucking, they're the ones that have to go fight those battles and pay those debts and stuff. All right, so now consolidation. Consolidation is when two or more corporations, they combine together. They don't know each other. They're not parent and child or whatever. They're just two corporations. They do probably two similar things, but maybe not identical things. So when two or more corporations combine together to form a completely different animal, a different corporation, that is a consolidation. So neither one of the original two corporations exists anymore. They've joined together to create this third corporation, a new one. It's distinct from either of the two predecessors. And there's no Florida law on this yet, so you don't have to worry about any of that. You just have to know what consolidation is, and that, in 20 years there might be some case law, so you want to stay up on it, but right now there's not. I don't want you to worry about share exchanges. I want you to jump right on over to, I want you to read what I have in the notes for you on rights and dissenting shareholders. Sometimes if you own stock in a corporation and they are going to merge or they're going to consolidate and you don't want to be part of that new company, you can sell your shares. You can sell your shares. You can sell your shares, and you can demand that they do an appraisal for market value, and then they have to pay you market value. And that's common. People do that a lot. So just remember that if you're ever in that situation. The purchase of assets. Let's see. Let's jump over here to there's one more important thing I wanted to tell you about. This last page, the hostile takeover. It's so sexy because we see it in the movies all the time. Well, to tell you the truth, it doesn't really happen that often. A hostile takeover, it doesn't happen very often in Florida, but they're very popular in the movies. This is true. The hostile takeover is a combination of corporations without the consent of the targeted corporation. So you have the good guys have their corporation and the bad guys want to take it over. And so what they do is they start communicating directly with the shareholders, and they either get the shareholders to all vote, yeah, we want to go with the bad guys, or the bad guys will just start picking off and start buying all the shares up. Like they'll try to get a 51% interest in this corporation that they're going to hostilely take over, and then they'll do a vote, and as long as they have the minority, then they can take it over. The aggressor corporation goes over the head of the target corporation's management and negotiates directly with the targeted company's shareholders, often offering large amounts of money, lots of cash for their stocks. This is governed by the Security and Exchange Act of 1934, as also as governed by the Williams Act of 1966. And these laws basically, they require that if you're going to try to get an acquisition of more than 5% of the ownership, then you have to let the SEC know. And that way, the target corporation, they can stay on top of this. They can stay on top of who's trying to buy shares of their stock and trying to gain a position in there. It's monitored by the target corporation in order to try to fight off the takeover. Like I said, these are very popular in the movies and there's lots of drama, but in reality, they have happened before, but they don't happen a lot. All right, and a leveraged buyout, that is when it's sort of a move that a corporation can take to try to avoid a hostile takeover. What they do is they have the corporation and another corporation is looming and it's coming in and it's kind of looking it over and wanting to eat, and it's starting to kind of dig in and try to get some of the shareholders to go their way. What the corporation can do, and I think Publix may have done this or thought about doing this, or they were a private corporation. They went public. They didn't really like being public, so then they bought up all their shares again from people from the outside public. Right now, in order to hold shares in Publix, you have to be an employee, or you have to be a former employee, and you can buy shares. But so it's privately held. There's a lot more people who are not able to hold shares in Publix than are able to hold shares in Publix. So if you're a public corporation and you decide, here comes the big takeover monster, it wants to come get you, you can start buying up, if you have the money, you can start trying to buy up all those shares that are owned by outside shareholders. And once it gets to be where everybody that's a shareholder is a privately, if they're the ones that are actually working the corporation, then they can say, oh, you know what, we want to go private. And by the way, all of our shareholders are already private holders. We're holding it privately anyway. So then once it's gone, it's a private company, and then these big corporations can't come after them, the hostile ones. Okay. And that is all I have for you this evening. So I will see you Tuesday talk time, or whatever day our talk time is, and we will go over any questions that you have on these last two areas. All right. Have a great evening, and if you have any questions, shoot me an email. Thanks.